Last week, the Washington Post did a little human interest profile on a burly ex-paratrooper who is the personal trainer for two of the justices who are currently sitting on the Supreme Court. In that profile, we learned that Justice Ruth Bader Ginsburg may be 80 years old. She may weigh less than 100 pounds. She may have survived very serious bouts with cancer twice already. But you know what? Ruth Bader Ginsburg can do more push-ups than I can. So behold, today, Justice Ruth Bader Ginsburg punching well above her weight at the much-anticipated Rock'em Sock'em Supreme Court oral arguments on same-sex marriage. Now, the first voice you're going to hear here is the voice of Paul Clement, who is the conservative attorney who's making the case for the anti-gay rights side. But then listen for Justice Ginsburg.
No state loses any benefits by recognizing same-sex marriage. Things stay the same. What they don't do is they don't sort of open up an additional class of beneficiaries under their state law that get additional federal benefits. But things stay the same. And that's why
they're not a question of additional benefits. I mean, they touch every aspect of life. Your partner is sick. Social Security. I mean, it's pervasive. It's not as though, well, there's this little federal sphere and it's only a tax question. It's as Justice Kennedy said, 1,100 statutes, and it affects every area of life. And so you would really diminishing what the state has said is marriage. You're saying, no, state, there are two kinds of marriages, the full marriage and then the sort of skim milk marriage.
Standing 5 feet tall from Brooklyn, New York, appointed by President Bill Clinton, Justice Ruth Bader Ginsburg, frankly, kind of winning the day today by christening this particular variety of American second-class citizenship as skim milk marriage, which is what it will forever be known as now. And by the way, in so doing, she skillfully was being very political there when she, in her admonishment of the attorney there, roped into her discussion the all-important swing justice on the court, Justice Kennedy. She roped him into her answer in a way that puts him on her side of the case. She's always doing stuff like that. It's amazing. Today was day 2 on this issue at the Supreme Court, right? Yesterday's case was about a state law, California voters amending their state constitution in 2008 to say that gay people are banned from getting married in that state. When a federal court struck down that California law as unconstitutional federally, as something that states may very well want to do, but the U.S. Constitution blocks them from doing it. When that happened, a weird thing happened in California politics. The California state government said, you know what? We actually think the judge is right here. We think our state's law, this amendment, is unconstitutional. And so we, the government of the state, are not going to appeal the judge's ruling, and we are not going to defend this bad law. We want to let it die. So that was a really interesting thing about day 1 of these 2 big cases of gay rights cases at the Supreme Court. Yesterday, they did fight some about the big underlying question of whether states can ban gay marriage or whether the U.S. Constitution blocks that. But mostly they fought about that weird thing about the way California handled it. And they fought about who has the right to defend that law when California's Attorney General refuses to defend the law. She was our guest last night on this show. Since she and California officially, as a state government, would not defend their ban on gay marriage, did the people who did want to defend it have the right to do so instead? And, frankly, could addressing that part of the question be a really convenient way for the Supreme Court to avoid the whole mishigas, the whole politically fraught question of whether gay people and straight people really should have equal rights in this country? So that was yesterday, where it looked like that standing issue, that issue of how the case got to the court, might end up diverting the court from making a decision on the big issue. That was yesterday. It was 1 hour's argument. It was about one state's law. Today it was 2 hours argument, and it was about a different case. Today it was not about one state's law. Today it was about a federal law. It was about one part of one federal law that starts with this. When Edie Windsor and Thea Spire got married in 2007, they had already been together for 42 years and counting. Ms. Spire by then had advanced MS. She had been told she had less than a year to live. They flew to Toronto. They got married. Thea died. And because of the Defense of Marriage Act, in death, Thea Spire was not recognized as having a surviving spouse. Now, at one level, this case, which led to today's arguments, it is an incredibly romantic story of these two young women in love who became two old women in love. A romance ended only in death in its 5th decade. But this case arises from not this romantic truth, but rather the rather unromantic mathematical truth of the law treating your spouse as a stranger in death, when other married couples are deferred to as a family. The 1996 Defense of Marriage Act puts a mandate on the federal government that the federal government must discriminate. The federal government, of course, doesn't perform marriages. Federal government doesn't issue marriage licenses. It never has. It's the states who govern who is and who isn't married. But under this law, under DOMA, the federal government has to comb through the marriages that the states do recognize and pick out the ones that are same-sex couples. And then it must overtly deny specifically to those couples all the rights that the other marriages get. At the court today, here was the lawyer for the pro-gay rights side, Roberta Kaplan, arguing that point with an interjection from Justice Stephen Breyer, who is the most professorial of all the judges, and you'll hear it in this clip. Check this out.
No one has identified in this case, and I don't think we've heard it in the argument from my friend, any legitimate difference between married gay couples on the one hand and straight married couples on the other that can possibly explain the sweeping, undifferentiated, and categorical discrimination of DOMA, Section 3 of DOMA. And no one has identified any legitimate federal interest that is being served by Congress's decision for the first time in our nation's history to undermine the determinations of the sovereign states with respect to eligibility for marriage. I would respectfully contend that this is because there is none. Rather, as the title of the statute makes clear, DOMA was enacted to defend against the marriages of gay people. This discriminatory purpose was rooted in moral disapproval, as Justice Kagan pointed out.
What do you think of his? The argument that I heard was, to put the other side, at least one part of it, as I understand it, said, look, the federal government needs a uniform rule. There has been this uniform one man, one woman rule for several hundred years or whatever, and there's a revolution going on in the states. We either adopt the revolution, or push it along a little, or we stay out of it. And I think Mr. Clement was saying, well, we've decided to stay out of it. The way to stay out of it is to go with the traditional thing. I mean, that's an argument. So your answer to that argument is what?
I think it's an incorrect argument, Justice Breyer, for this reason.
I understand you do. I'd like to know the reason.
Of course. Congress did not stay out of it. Section 3 of DOMA is not staying out of it. Section 3 of DOMA is stopping the recognition by the federal government of couples who are already married solely based on their sexual orientation. And what it's doing is undermining, as you can see in the briefs of the states of New York and others, it's undermining the policy decisions made by those states that have permitted gay couples to marry. States that have already resolved the cultural, the political, the moral, whatever other controversies they're resolved in those states. And by fencing those couples up, couples who are already married, and treating them as unmarried for purposes of federal law, you're not taking it one step at a time, you're not promoting caution, you're putting a stop button on it, and you're having discrimination for the first time in our country's history against a class of married couples.
Discrimination, says the side that wants what it sees as discrimination overturned. And of course, in that argument, she gets an assist, sort of, from one of the more liberal justices who is probably inclined to agree with her assessment. Now, as to the other side, here's what's really interesting. Like the California case yesterday, there is a kind of strange situation about the anti-gay side in this case, wherein the government, whose law this is, doesn't want to defend it. This is a federal law, remember? And President Obama and his Justice Department and the Solicitor General agree that this is a bad law. They think this law is discriminatory and that it's unconstitutional, and they are not defending it. So who's defending it then? Somebody else had to be brought on board to defend it. And in this case, it was the House Republicans. Hi, John Boehner, who decided that they would defend it with your taxpayer money. They hired a really good conservative lawyer named Paul Clement to argue their side, to argue the anti-gay rights side of this, to argue to uphold the law. And Paul Clement's argument today was, of course, that this isn't discrimination at all. It's just that the federal government likes to keep things simple. Listen.
I think what that shows is that when the federal government gets involved in the issue of marriage, it has a particularly acute interest in uniform treatment of people across state lines. So Ms. Windsor wants to point to the unfairness or the differential treatment of treating two New York married couples differently. And, of course, for purposes of New York law, that's exactly the right focus. But for purposes of federal law, it's much more rational for Congress to say, or certainly a rational, available choice for Congress to say, we want to treat the same-sex couple in New York the same way as the committed same-sex couple in Oklahoma and treat them the same. Or even more to the point, for
but that's begging the question, because you're treating the married couples differently.
Well,
you're saying that New York's married couples are different than Nebraska's.
But the only
I picked
way
that out of a hat. But the point is, there's a difference.
The only way there's difference is because of the way that state law treats them.
Right. The way that states' laws treat them. States' laws treat gay people and straight people differently. And the question here is whether the federal government should be part of that discrimination, whether the federal government should, in fact, compound that. For an answer to that, we go to the heavy hitter of the day, Justice Ginsburg. Go.
Mr. Clement, the problem is that it would totally thwart the state's decision that there is a marriage between two people for the federal government then to come in and say, no joint return, no marital deduction, no Social Security benefits. Your spouse is very sick, but you can't get leave. People, if that set of attributes, one might well ask, what kind of marriage is this?
And I think the answer to that, Justice Ginsburg, would be to say that that's a marriage under state law.
Ow. And that's whereupon, in the arguments, we got to the point where Justice Ginsburg ended up calling those marriages skim milk marriages, which, frankly, is a grave offense to skim milk, which is delicious, but is otherwise kind of amazing and will stick. We have the expert in the country on this case, like the single expert in the country on this case, who's here in just a moment to talk about how this all went today and what happens next and how these oral arguments might tell us what's going to happen on this issue. But before we do that, there's one other thing from today's case that I think is totally worth hearing. This is not one of those smackdown moments for either side, but it was the very, very end of the day today. It was the very end of the arguments, the very end of the 2 hours, and it showed the strange and it's this unstable political core that's at the heart of these legal fights, right? Because we have fights about the law, but those fights about the law do not happen totally independent of the political world in which we live. And the combination of legal and political sometimes gets a little woolly. And it was Chief Justice John Roberts today who showed that most clearly. In him trying to make the case that gay people should not be protected against discrimination. Because gay people aren't discriminated against in this country. And the way you can tell that gay people aren't discriminated against in this country is that discrimination against gay people in some cases is starting to be politically embarrassing for the bigot. And also, he points out, gay people have really good lawyers now. And he says that to the gay rights lawyer arguing before him at the Supreme Court. It's a really strange and kind of unstable moment. This is the last piece of tape I want to play for you. It's at the very end of the argument. Just watch this.
I suppose the sea change has a lot to do with the political force and effectiveness of people representing, supporting your side of the case?
I disagree with that, Mr. Chief Justice. I think the sea change has to do, just as was discussed in Bowers and Lawrence, with an understanding that there is no difference, there is no fundamental difference that could justify this kind of categorical discrimination between gay couples.
You don't doubt that the lobby supporting the enactment of same-sex marriage laws in different states is politically powerful, do you?
With respect to that categorization of the term for purposes of heightened scrutiny, I would, Your Honor. I don't.
Really?
Yes.
As far as I can tell, political figures are falling over themselves to endorse your side of the case.
The fact of the matter is, Mr. Chief Justice, is that no other group in recent history has been subjected to popular referenda to take away rights that have already been given or exclude those rights the way gay people have. And only 2 of those referenda have ever lost. One was in Arizona. It then passed a couple of years later. One was in Minnesota, where they already have a statute on the books that prohibits marriages between gay people. So I don't think, and until 1990, Gay people were not allowed to enter this country. So I don't think that the political power of gay people today could possibly be seen within that framework, and certainly is analogous. I think gay people are far weaker than women were at the time of Frontiera.
Well, but you just referred to a sea change in people's understandings and values from 1996 when DOMA was enacted, and I'm just trying to see where that comes from, if not from the political effectiveness of groups on your side of the case.
To flip the language of the House report, Mr. Chief Justice, I think it comes from a moral understanding today that gay people are no different and that gay married couples' relationships are not significantly different than the relationships of straight married couples. I don't think that...
Well, I understand that. I'm just trying to see where that moral understanding came from, if not the political effectiveness of a particular group.
I think it came, again, very similar to the what you saw between Bowers and Lawrence. I think it came to a societal understanding. I don't believe that societal understanding came strictly through political power. And I don't think that gay people today have political power, as this Court has used that term in connection with the heightened scrutiny analysis.
Thank you, Ms. Kaplan.
And that was it. That's how it ended, on that incredibly intense moment of how come it is that gay people aren't so hated that you can be here arguing for this now? Doesn't that mean that you've got access to people like me?
Friends, Romans, countrymen, lend me your ears. We do not give up. Expect surprises. Subscribe.